I am Gregory Brown with the law firm of Brown and Charbonneau here in California. Today, we're going to talk about protecting your intellectual property. Many clients want to know more about protecting their business assets and intellectual property. So let's just dive in. Intellectual property is often an organization's most valuable asset. So it's important that you know how to protect it from infringement and theft. Depending on the nature of your intellectual property, it may be protected under patent, trademark, or copyright law. A discussion on trade secrets is the topic of another video. So let's review the basics, starting with patents. Patents protect scientific, mechanical, or technical inventions. A patent awards the inventor the exclusive right to make, use, and sell a particular invention for a limited period of time. To obtain a patent, you must file an application with the U.S. Patent and Trademark Office. Before you start that process, though, you'll want to make sure that your invention is, in fact, patentable. A key step will be conducting a preliminary patent search to make sure that no one else has previously patented the same or similar invention. Once obtained, if your patent is infringed upon, you can file a civil lawsuit to enforce your rights. If you're successful, the court will award you monetary compensation for the harm your business has suffered as a result of the infringement. Plus, the court may, in its discretion, issue an injunction on any terms the court finds to be reasonable and equitable. As a practical matter, however, before you file a lawsuit, consider whether you might be able to negotiate a licensing and royalty agreement with the infringing party. This business-based approach may prove to be faster, less expensive, and ultimately more rewarding as an alternative to litigation. Now let's talk about trademarks. Any symbol, name, slogan, or other device by which the public identifies your business and its products is a trademark. To protect your trademark, register it with the U.S. Patent and Trademark Office. Registering your trademark puts the public, including potential competitors, on notice that the mark is associated with your brand, that you own it, and that you have the exclusive right to use it in commerce. If a competitor uses your trademark without your authorization, and that use, whether intentional or not, causes consumers to confuse your product with the competing product, this is trademark infringement. Your legal remedies for trademark infringement include injunctive relief, monetary compensation, and your costs associated with the infringement action. Finally, let's talk about copyright. Copyright law protects the tangible fruits of the creative process. In other words, art, literature, photographs, films, and musical compositions. A creative work is copyrighted as soon as it is fixed in a tangible form. It need not be officially registered with the U.S. Copyright Office to enjoy copyright protection. However, if your business produces original creative output, the safer course of action is to formally register the work. Registration gives you A, the right to attach an official copyright notice to the work, and B, a safety net in any case of copyright infringement. If your copyright is infringed upon, consider taking a measured approach to enforcing your rights. Start by sending a cease and desist letter. If that doesn't work, have an attorney send a cease and desist letter. If those efforts fail, you can file a lawsuit. Now, the remedies available to you if your lawsuit is successful include monetary compensation for the losses you sustained as a result of the infringement, plus any additional profits earned by the defendant. Or if your copyright is registered with the U.S. Copyright Office, you may choose an award of statutory damages instead. If you go this route, you do not have to prove your losses or the defendant's profits. Once you establish copyright infringement, you will be compensated according to the terms of established in the Federal Copyright Act. If your copyright is not registered, you don't have this option. Now, for more information on this topic or other business-related disputes, call us today at 714-505-3000. Let's talk about these protections in greater detail, and specifically with regard to your business and the particular facts of your situation.